Hi everyone. Today we're going to talk about types of property that exist in family law. So first up is community property. Community property is defined in Code Section 770A1 Family Code. It states in a negative way that everything that's separate is not community, meaning anything acquired during the marriage by the parties domiciled in California and that is not specified in other code section as separate property is considered community. And separate property is defined in 770A3 Family Code section, and it states inheritance, gift, produced by separate property through, for example, rents, issue, profits. See it as someone has an account before the date of marriage and that produces interest. And there's no one who puts personal effort into managing these accounts, so it's sort of automatically, or someone else manages these accounts, it is considered separate property. The moment community starts to put effort into separate property, community starts to acquire some interest. So that's why prenups are very interesting and good to consider before getting married, because if someone has a lot of separate property and is not planning to work during the marriage but manages all of that, so it's got to be very clearly adjudicated, or it has to be decided through a prenup. So reimbursement of separate property are defined in 2640 Family Code section, and it's typically contribution to acquire separate property or community property can be reimbursed dollar for dollar without interest. I actually don't like this law because let's say someone puts $100,000 into a down payment of family residence, and 20 years ago $100,000 was something else compared to now. 20 years ago gas was, let's say, $1, now it's $6. So you see the difference. I would say the house, I would say the 100,000 needs to be compared to the value of the house at the time, and I would expect the legislature to change this code section to say that the down payment has to get the same value as if the house, let's say the house was purchased for $1 million, was 100,000 down payment. Now the house is 10 million. So the 100,000 needs to be at least 1 million, right? Because everything grew in value because of that down payment. So, but that's my personal opinion. So the law states no interest. Then there's another, so we said community property, separate property, quasi-community property. Quasi-community property is something that was purchased outside of California. And I'm talking about not just outside of California within the United States, it's outside of California, period, anywhere in the world. That would have been community property if and while one of the parties or both parties were domiciled in California. So again, the complication of the sentence means that it's not separate property, right? So if it's not purchased before the marriage, not after separation, not with community funds, so what would have been otherwise in California law community property, it's considered quasi-community property just because they don't domicile in, because they domicile here and purchase somewhere else, it doesn't mean that it's not community property. What if they purchased it while they were traveling and domiciled somewhere else? Well, in that case, it depends where they file for divorce and where they domicile now. And the court will look over quasi-community, community property at the time where divorce is filed. And in order to file for divorce in California, you have to live in California for 6 months, at least 6 months, and in the county for 3 months. Then there is so-called quasi-marital property, acquired by either party to an invalid marriage that otherwise would have been community property if the marriage was valid and one spouse has been declared putative spouse. Let me break it down. Code section 2251. So imagine someone thinks he got divorced from spouse number one and thought received judgment paperwork, and then didn't know that wife number one actually dismissed that somehow without his consent. Happened actually, for real. And then husband marries wife number two, and the marriage is voidable and potentially even void because he never got divorced from wife number one. And so wife number two thinks the marriage is valid because not only the act, she has no reason to doubt because he said, I'm divorced. And so in that case, the property acquired together is considered quasi-marital property. And why do we call the wife number two putative spouse? Because number one, she had good faith belief that the marriage was valid and acted as such honestly considering totality of the circumstances. Has to be reasonable. So what does it mean? If he ever told her, I'm not sure that my marriage is valid or something like, it's not reasonable, a reasonable person will acquire. What do you mean? So it has to be really honestly based on totality. She cannot be turning a blind eye or acting, I don't want to know. So it's got to be 100% honest. All right. So we said community property, separate property, quasi-community property, quasi-marital property. Now, joint tenancy. So joint tenancy is property owned by two or more in equal shares and expressed in a form of declaration, title, and the difference between all other properties is that in joint tenancy, especially spouses take homes when they acquire homes as joint tenants, it has the right of survivorship. So typically when someone dies, their share goes to their heirs based on the will, trust, whatever they created. In joint tenancy, it goes automatically to the other person or people, whoever are joint tenant in equal shares. So when couples are going through divorce, I strongly suggest to terminate joint tenancy if the spouse divorcing the other spouse doesn't want, if in that case, to get everything to the other spouse, right? So terminate it, find out how to. This video is not about that, but just keep it in mind. Then there is tenancy in common. That's everything else. It's not community property, it's not partnership, it's not joint tenancy defined in section 750. Not very common in my practice, so I'm not going to spend too much time on that. Then partnership, co-own for profit purposes, for example, business, right? Spouses own business together, they co-own it, also defined in Family Code section 750. And then community property with right of survivorship, similar to joint tenancy, just not joint tenancy, anything else. All right, next, factors of factors of when community property is acquired. So in order to determine whether it's community separate, we have to look at the date of acquisition. So 770 Family Code section states anything before marriage, separate property. Clear on that. During the marriage, before separation, is presumed community property. The key word here is presumed, meaning whoever is claiming something to be separate property has by preponderance of evidence show and trace separate property. So the burden of proof is on the person who claims separate property, number one. Preponderance of evidence means more likely than not, or 50% or more true that that person is right about separate property. And how do we trace? Tracing can be done through bank accounts. For example, I suggest to keep your bank records very, very neatly organized online, not just in boxes, because things get lost. Happens so many times, and banks don't keep records mostly for more than 7 years, so keep that in mind. Now, if you can prove that you had $100,000 in your bank account before the date of separation, and you can prove the next bank account, escrow account, that when that $100,000 for the down payment of that house, then you did the tracing. If you don't have the bank accounts, you can still prove the tracing with your testimony, and it comes to credibility. So it's going to be she said, he said, or vice versa, and then the judge will decide based on credibility factors. So it's better to have tracing through evidence than words. All right, during the marriage, so now what is separate property? Anything that is acquired after date of separation that is not done with community property money, right? With earned money through personal effort. And date of separation is defined in Family Code section 7.0. We have to have a few, couple important points. Number one, express intent to the other spouse to end the marriage. You cannot sit and hold and say, this is over, and the other spouse doesn't know, you go on vacation and do whatever you want. So it has to be expressed. Number two, conduct as such. Your conduct should show that the marriage has ended, meaning any communication about children and assets are fine, but no vacation, no holiday together and act like husband and wife, sleeping in one bedroom. So since Davis case, there is no need to move out in order to show that you're separated. So husband and wife, especially in California, it's very expensive to move out with many kids or not. It's just not necessary anymore. So, and it was removed from a code section, meaning it has to be consistent. So no vacation, no birthday together, no meaningful way other than children and asset to communicate with each other and have intimacy. There was a case, I'm going to spell it out, Baragry case that was about case of appeal in California. Baragry. Kind of difficult to pronounce, but okay. So the date of separation was 4 years ago. A doctor moved on a boat with his girlfriend for 4 years, but he came to dinner to his wife. He joined social events with her. He let his laundry be washed by her, so she washed his laundries, and they did joint taxes together. And the court said, even though you lived with a girlfriend, you acted as if not. So point number 2, conduct was not consistent. Therefore, date of separation was not 4 years ago, is now. And then some people think, oh, if I file for divorce, and then let's say this, even if in this case he filed for divorce right away, moved with his girlfriend, but then he still acted as if filing for divorce without pursuing the divorce is not considered as an act of date of separation by filing. So it has to be filed and pursued. And also the Family Code section 7.0 has to be followed. So express the intent to separate and end the marriage, plus act as the marriage will be ending. And if you file for divorce, then pursue the action that are required for the process of a divorce. Okay, and then so during the marriage, anything acquired through personal effort, meaning if someone goes to work, makes money, and even there's a couple cases, Pierre and Van Camp, I'll have another video on that, when someone puts effort into separate property business, then the court has a formula, or not the court, the legislature has a formula how to calculate how much is acquired in the community. And usually in these cases, I ask to hire an expert to do the calculation. So I hope that was helpful. I will see you soon. Bye.